let's uh let's begin again. So this is part two. So our topic for the next topic would be Lex Judicata. So the requisites for Lex Judicata is that the former judgment must be final, and the judgment or order must be on the merits. It must have been rendered by a court with the jurisdiction over the subject matter. It must have been rendered by a court with jurisdiction over the parties to the case, due process purposes. There must be, between the first and the second action, identity of the parties, subject matter, and cause of action. So, res judicata applies in quasi-judicial proceedings. It does not apply to criminal proceedings because double jeopardy applies therein. So, if you look at this, you cannot, uh, you are barred to have, if there's a final judgment and then there's another case with regards to a civil case within the same, it will be res judicata as the same concept as double jeopardy in criminal cases. So next would be former judgment must be final. So this means final and executory judgment. So example would be judgment must be on the merits. This means the decision was with prejudice or adjudication based on the evidence presented by the parties. Example, Mr. A filed an action or collection of sum of money against Mr. B. The RTC Manila dismissed the action for improper venue. Later, Mr. A filed another action for collection of money for the RTC Mandaluyong. Was there a res judicata? No, because the judgment on the first case was not on the merits. It was dismissed, not based on the evidence presented, but based on the affirmative defenses. Another example would be, would it amount to litis pendentia? No, because the second action was filed after the termination of the first action. Litis pendentia presupposes the presence of two pending actions, which is simultaneous. Example, Mr. A filed an action for collection of sum of money against Mr. B. The RTC ruled in favor of Mr. B. During the appeal period, Mr. A filed another action for collection of sum of money against Mr. B. Was there res judicata? No, because the former judgment was still not final. However, there was litis pendentia. Judgment must be on the merits. This means the decision was with prejudice or adjudication based on the evidence of the parties. Example, Mr. A filed an action for collection of some money against Mr. B. The RTC Manila dismissed the action for improper venue. Later, Mr. A filed another action for collection of sum of money with the RTC Mandaluyong. Was there res judicata? No, because the judgment on the first case was on the merits. It was dismissed, not based on the evidence presented, but based on the affirmative defenses. Would it amount to litis pendentia? No, because the second action was filed after the termination of the first action. Litis pendentia presupposes the presence of two pending action. Naulit pala natin to. Okay. Court with jurisdiction over the subject matter. Jurisdiction over the person of the defendant due process. Example, Mr. A filed an action for collection of sum of money against Mr. B. The sheriff resorted to substituted service of summons after one attempt. Thus, Mr. B was never notified of the action. Later, the RTC declared Mr. B in default upon motion. The RTC ruled in favor of Mr. A. The decision attained finality. Mr. B only knew the outcome of the decision after the sheriff went to his house to execute the judgment. Thus, thus, Mr. B filed an action for annulment of judgment with the CA. Was there a res judicata? No, because the judgment in the first case was rendered without acquiring jurisdiction over the person of Mr. B. Court with jurisdiction over the subject matter. Mr. A filed an action for collection of sum of money against Mr. B. The amount of the demand was 1 million. The artist dismissed the action for lack of jurisdiction over subject matter. Later, Mr. A filed another action for collection of sum of money with the MTC. Was there res judicata? No, because the court had heard the first case and no jurisdiction over the subject matter. Further, the judgment was not on the merits because the first case was dismissed based on affirmative defenses. Jurisdiction over the person of the defendant, identity of parties, subject matter, and causes of action. Just follow the discussion in litis pendentia. Example, Mr. A filed an action for collection of sum of money against Mr. B. The sheriff resorted to substituted service of, of summons after the attempt. Thus, Mr. B was never notified of the action. Later, the artist declared Mr. B in default upon motion. The artist here ruled in favor of Mr. A. The decision attained finality. Mr. B only knew the outcome. After the sheriff went to the house, Mr. B filed an action for annulment. No, same example. Mr. A filed an action for change of name under the rules. All persons interested, such as the parents of Mr. Shelby, served summons. The sheriff resorted to substitute the service of the summons after the attempt. Thus, the parents of Mr. A was never notified of the action. Later, the RTC declared the parents of Mr. A in default upon motion. The RTC ruled in favor of Mr. A. The decision attained finality. The parents only knew the outcome of the decision after the sheriff went to his civil register to change the name of Mr. A. Thus, the parents filed an action for annulment of judgment with the CA. Was there res judicata? No, because the judgment in the first case was rendered without acquiring properly serving the summons to the parents. Thus, it was rendered in violation of the right to due process of the parents. Joinder of causes of action. In joinder of causes of action, party in one pleading asserts in the alternative or the otherwise as many causes of action as he may have against an opposing party. Joinder of causes of action is always permissive. The provision used the word may. Such joinder is subject to the following conditions. Mode of cancellation. Shall comply with the rules of joinder of parties. Shall not include special civil action or actions governed by special rules. If it pertains to different venues or jurisdiction, the joinder may be allowed in the RTC, provided one of the COA falls within the jurisdiction of the court and the venue lies therein, and, and where the claims in all the causes action are principally for recovery of money. The aggregate amount claimed shall be the test of jurisdiction. Note, these are conditions. If one condition is absent, the causes of action cannot be joined. Thus, mode of cancellation must be observed. Permissive joinder of parties. Note, the causes of action must arise out of the same transaction or series of transactions. Section 6, Rule 3. If there was a misjoinder of the parties, in Section 6, Rule 3, there would also be misjoinder of causes of action. Thus, the claims must be severed and tried separately. Scenarios. Mr. A lent money to Mr. B and Mr. C on separate dates. If both of them fail to pay upon demand, can Mr. A file suit against them? No, because there would be misjoinder of parties. The transaction were different. Mr. A lent money to Mr. B and C as joint debtors. If both of them fail to pay upon demand, can Mr. file one suit against them? Yes, because the claims arose from the same transaction. Mr. B and Mr. C bumped in their cars. Ano, mami? Wala, wala. Nagre-review ako. Okay na yan, mami. Ako na bahala dyan, mami. Kaya ako, mami. Mr. A lent money to Mr. B. Mr. C mis- lent money to Mr. B, Mr. C as an accommodation mort mortgage his property in order to secure a loan obtained by Mr. B. If B fails to pay upon demand, can Mr. A join Mr. B and Mr. C in one action? Because yes, because A's claims arose from the series of transaction. However, there is only one cause of action because only Mr. B failed to pay. Now that what if Mr. C also failed to pay upon demand? Still, there's one cause of action. Accommodations of mortgagor are not in any way liable for the payment of the loan of the debtor. The liability of the accommodation extends only up to the loan value of the mortgage property. Special civil actions governed by special rules. Partitions and collection of sum of money cannot be joined because the partition is special civil action. Forcible entry and collection of sum of money cannot be joined because forcible entry is a special civil action. Settlement of estate and the conveyance of property cannot be joined because settlement of estate is special proceeding. Quieting of title and action for the conveyance. Question: Mr. A has two causes of action. Mr. B against Mr. B. One, failure to pay 100,000. And two, failure to pay to the Emilia. Can Mr. A join the two causes of action in one suit? Before the rules of expedited procedures in first level courts, they cannot be joined because 100,000 claim will be subject to special rules, while the 3 million claim will be subject to ordinary rules. However, after the rules effectivity, they can be joined. Why? Because the rules in expedited procedure in first level courts shall not apply to civil cases where the plaintiff cause of action is pleaded in the same complaint with another uh with another with another cause of action subject to the regular procedure. Thus, they can now be joined because the expedited rules, small claims will not apply. Different venue or jurisdiction joinder in the RTC. Note, the section states RTC, not MTC. A has two parcels of land. The first has assessed value of 5,000, while the second has an assessed value of 5 million. The properties are situated in different provinces. B forcibly entered into both of those parcels of land in 2019. It is now 2021. How can A pursue his claims against B? A can join both this cause of action against B with the RTC of the province where the second party is situated. A has two parcels of lot with an assessed value of 5,000 situated in different provinces. B forcibly entered to both of those parcels of lots in 2009. How can A pursue his claims against B? A must file separate suits of action publicana in the MTC of each province, where the parcel of land under the rules when the causes of action between the same parties pertain to different venues. The joinder may be allowed in RTC. It did not state MTC. Thus, they cannot be joined. Follow-up question. Can this be covered by totality rule? No, because the totality rule only applies to amounts of claim or demand. A has two parts of the flood. The first has an assessed value of 5,000, while the second has an assessed value of 5 million. The properties are situated in different province. B forcibly entered. How can A pursue his claims? A must file separate suits of forcible entry against B. An action for forcible entry cannot be joined because it is a special civil action. Totality rule. In Rule 2, in BP 129, and in BP 129, whether it is the rule of court or BP 129, the totality rule merely applies to monetary claims, collection of sums money, or action for damages. It does not apply to actions involving title or possession of real property. You cannot join the assessed value of two properties, treat them separately. Misjoinder and non-joinder causes of action. Misjoinder of causes of action is not a ground for dismissal of an action. Disjoint causes of action may on motion, may uh action of action may on motion of party on the initiative of the court be severely proceeded separately. Note the word is may. Thus, misjoined causes of action can be tried in the same action if the court did not sever them. Meanwhile, for the non-joinder causes of action, the court cannot compel the plaintiff to join the causes of action in one suit. Why? The repeat joinder causes of action is permissive in nature. That ends our rule 2.